Office of the Solgen earlier said the Chief Justice is unlawfully holding her post, citing her alleged failure to submit her statements of assets, liabilities, and net worth over a 10-year period when she applied for the top magistrate's post in 2012. Sereno cites lack of jurisdiction and lack of merit for the plea, adding impeachment is the only way to remove a sitting chief magistrate.
The third article,
House Justice Committee Chair Ray Umali says if the court rules favorably on the OSG's petition and nullifies Sereno's appointment in the first place, then an impeachment trial will become moot and academic.
Kasi pag yung sa Supreme Court ay nanalo ang Solgen or nanalo yung state, then mababaliwala lahat yan.
And the Chief Justice wants her day in court.
She is actually eagerly awaiting the transmittal of the articles of impeachment to the Senate. And she has been asked this before, and she said that she's actually in the advanced stage of preparation. She is very prepared.
Is the petition for quo warranto filed against Chief Justice Maria Lourdes Sereno before the Supreme Court proper, considering her appointment was void ab initio?
Arguing for the affirmative side is the Cor Jesu College. All the way from the gate city of the South, Digos, Davao del Sur, the next generation lawyers from Cor Jesu College.
I'm a believer of the yes theory. We're seeking the uncomfortable and learning at the end of the day. I took up law because of the persuasion of my dad, because he's also a lawyer in Davao. And since the opportunity was there, I grabbed it to jumpstart my career as a diplomat in the future.
I take to heart the 90-10 principle wherein whenever faced with whatever situation, what matters more is how you handle that situation. I have always been interested in criminal law and the criminal justice system, and growing up, it has always been my plan to take up law.
I took up law because I want to become a part of that group of professionals who actually is fighting for justice. And it is my advocacy to help the poor also someday.
Team Cor Jesu College. Dedicated, passionate, determined. Taking on the negative side is the University of Batangas. From the university in pursuit of knowledge, values, and skills, the next generation lawyers from the University of Batangas.
I actually was a BS Biology graduate, but I took up law school because I wanted to help the people who cannot help themselves.
I am a structural design engineer, and my friends find it odd that I entered law school. I took up law school because I want to be an environmental engineering lawyer someday.
I'm fun to be working with people, and it brings me a lot of happiness to see people working in unison to achieve a common goal. I took up law school because I want to realize my dream of providing quality legal services for the poor.
Team University of Batangas. Spirited, intellectual, tenacious. Let's now meet our distinguished judges. First off, we have Attorney Antonio Lu, a senior associate at the VNA Law Firm. Next, we have Attorney Ferdinand Casis. He's a professor at the Ateneo School of Law. He's also a lecturer at the Philippine Judicial Academy and Center for Global Best Practices. And presiding as our chief adjudicator this evening is retired Judge Dolores Espanyol, chairperson of the group Transparency International. The word war begins when Square Off Season 15, The Firm Debates returns. Please stay tuned. We're using a modified Oregon Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask one question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition, let it be resolved that the petition for quo warranto filed against Chief Justice Maria Lourdes Serrano before the Supreme Court is proper, considering that her appointment was void ab initio. First up, for the affirmative side, we have Kim. Kim, you've got 4 minutes to argue the need to consider as proper the petition for quo warranto filed against the Chief Justice Maria Lourdes Serrano.
Void appointment begets void office. Ladies and gentlemen, your honors, good evening. On the motion that let it be resolved that quo warranto proceeding against TJ Serrano is proper since her appointment was void ab initio, affirmative exclaims a resounding yes, because we believe that her appointment is tainted with illegality and therefore a quo warranto proceeding is proper to remove her from office. First, the appointment of CJ Serrano is void ab initio. Failure to submit one SALN means there is a failure to meet the requirements for proof of integrity. Failure to prove integrity means a person is not qualified for the position. And an appointment of a person not qualified for a post is an appointment void ab initio. The 1987 Constitution, the rules of the Judicial and Bar Council, and jurisprudence provide that a member of the judiciary must be a person of proven competence, integrity, and probity. Specifically, the JBC Rules number 009, Rule 4 thereof states that the Council shall take every possible step to verify the applicant's records and of reputation for honesty, integrity, incorruptibility, irreproachable conduct, and fidelity to sound moral and ethical standards. In 2012, the JBC required applicants to the post of Chief Justice to submit their SALNs up to December 31, 2011 for those in the government service, and also required applicants to make a waiver of confidentiality of their local and foreign bank accounts. These two requirements go together, since the SALNs will be double-checked with that of the applicant's bank accounts. Why then are these relevant? Because these documents will go into scrutinizing an applicant's integrity in her assets, liabilities, and net worth. However, CJ Serrano submitted to the JBC her SALNs only for the years 2009, 2010, and 2011, when it should have been 10 SALNs for every year since 2002 as substantial compliance. Anything less than that is obviously not substantial compliance. Even prior to becoming part of the judiciary, it was also found out that Serrano failed to submit her SALNs for several years, from 1986 to 2006, when she was still full-time faculty of the UP College of Law. This is not a mere shortcoming, but a grave violation of the law. It is no less the Constitution that prescribes the rule that a public officer or employee shall upon assumption of office, and as often as thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. Moreover, RA 6713 also requires the same. As stated in the case of the Ombudsman versus Nestor S. Valleroso, the Supreme Court ruled that the SALN is a valid check and balance mechanism to verify undisclosed properties and wealth. If indeed she is a person of integrity, why then could she not produce these documents? The absence of her SALN is not merely a simple mistake that can be overlooked, but a failure to meet the requirements set forth by law. On to my next argument. Since Serrano's appointment is void ab initio, affirmative now submits that in accordance with the Constitution, law, and a host of jurisprudence, a quo warranto proceeding is a proper legal remedy to oust her. Section 1, Rule 66 of the Rules of Court provides that a quo warranto proceeding can be filed against a person who usurps, intrudes into, or unlawfully holds or exercises public office or position. Since there is now a question on the validity of her appointment, a quo warranto is indeed a proper remedy because she is unlawfully holding an office which she is not qualified for in the first place. Second, the ruling in Funa versus Villar is clear that the quo warranto proceeding... Yes, Your Honor.
Are you saying that the rules of court is paramount to the provision of the Constitution?
Yes, Your Honor, since the rules of court were precisely created by the court in order to provide for the rules in court that would be mandated as for the hearings and for trials, and in this case, a quo warranto proceeding is provided for in the rules of court. To proceed, Your Honor, the ruling in Funa versus Villar is clear that a quo warranto proceeding may be resorted to even against impeachable officers.
2 minutes for the cross-examination.
May the Chief Justice be ousted by a means other than impeachment? Yes. Are you familiar with the letters of Article 11, Section 2 of the Constitution? Yes. Does it provide for other means? No, but if you read the Constitution, the word there yes or no? May. Yes or no, Mr. Speaker? Yes or no? No. Okay. Is the Constitution the fundamental law of the land? Yes, of course. But you said earlier that the Constitution should... Again, if you read the Constitution, the word there is may, and does the Constitution reflect the sovereign will of the people? How come again? Does the Constitution reflect the sovereign will of the people? Yes, of course. Then it follows that all laws should conform to the provisions of the Constitution. Yes, of course. Yes, both substantive and procedural law. Yes, of course. Yes. Can procedural law enlarge the coverage of the Constitution? Of course not. Yes, of course not. Then, is quo warranto provided in Article 11, Section 2 of the Constitution? Again, it is our submission that the word there is may. Is it provided? Yes or no? Yes or no, Mr. Speaker? Yes or no, Mr. Speaker? Is it provided? Is it provided? Qualified yes. No. Qualified yes. Is quo warranto provided in Article 11, Section 2? It is our submission that the word there is may. My question is it provided? No. No. The present case enlarges the provisions of the Constitution by adding quo warranto to the possible remedy. Again, it is clear in Puna versus Villar that the quo warranto proceeding can be filed against an impeachable officer. No further questions.
Okay, Denji, you've got 4 minutes now to advance your argument on why we need not consider the quo warranto petition against Chief Justice Sereno as proper.
Your Honor, some points of rebuttal before I proceed to my main constructive. The affirmative seems like to mislead us by citing obiter dicta and overturned jurisprudence and arguments without basis in the Constitution nor in jurisprudence. They cite that Constitution should bow down to the rules of procedure promulgated by the Supreme Court. This is not true. Everyone here knows that. And in the case of Hardaleza versus Sereno, failure of filing the SALN does not equate to lack of integrity. These are questions of fact which is to be determined in the proper proceedings. Proceeding to my constructive, Your Honors, the Constitution is the fundamental, paramount, and supreme law of the nation. It accepts no derogation, direct or otherwise. Ladies and gentlemen, Your Honors, good day. It is our position that it is unnecessary and it is improper for a quo warranto case to be filed against Chief Justice Sereno, mainly for one point. The Constitution already provides the mandatory procedure regarding her removal from office. This will be discussed in 3 levels. First level, Section 2 of Article 11 of the Constitution provides that the members of the Supreme Court may be removed from office by impeachment. While the word may, on its face, appears permissive, a close scrutiny of the records of the Constitutional Commission deliberations would reveal otherwise. The framers of our Constitution, in drafting and redrafting this particular provision of the Constitution, refer to the justices of the Supreme Court as officials who may be removed only by impeachment. This they did consistently without objection nor dissent. Second level, in the case of Jokno versus Rehabilitation Finance Commission, it was held that the words may, must, and shall are often used without intending that they be taken literally, and that in understanding their true import, the objective evidently designed to be reached limits and controls the literal import of the terms and phrases employed. It is well settled that the intention of the framers of the Constitution in drafting this provision is the protection of the impeachable officers from immediate removal and from being unduly vexed. As to my third point, Your Honors, the intent of the framers is reflected in a long line of Supreme Court decisions. In the case of Cuenco versus Fernan, the Supreme Court dismissed disbarment proceedings against the then Justice Fernan for the reason that members of the Supreme Court may be removed only through impeachment. In the case of Licaros versus Sandigan Bayan, it was held that any criminal charges filed against impeachable officers which carry with it the penalty of removal from office is constitutionally proscribed. In the case of Ombudsman versus Court of Appeals, it was held that it was solidified the rule that an impeachable officer cannot be prosecuted for offenses which constitute a ground for impeachment. Your Honors, jurisprudence is consistent. Any action other than impeachment, be it disbarment or criminal proceedings or any other hokum we could conjure,
it will not prosper because it is a circumvention of the mandate of the Constitution. The quo warranto proceeding in this case is of the same class as those mentioned and must likewise be struck down as unconstitutional. Moreover, procedural law must be utilized to the end of enforcement of substantive law and must be congruent to the Constitution and must not be a substitute therefore or a derogation thereof. That is all, Your Honors. I'm ready for your micros.
2 minutes for the cross-examination.
So, good evening, Mr. Speaker. Good evening. So, you obviously read the Constitution, correct?
Of course.
So, does it say that impeachment is the sole means of removing a Chief Justice?
No, but that can be gleaned from the
Okay,
intent.
so is there any kind of prohibition with regard to the removal of a Chief Justice other than impeachment?
The intent of the framers of the
Yes or
Constitution.
no only, Mr. Speaker?
Yes.
Okay, in fact, Article 11, Section 2 of the Constitution provides that these officials may be removed from office on impeachment, correct?
Yes.
And the operative word there being is may, correct?
Yes, of course.
And you would have to agree that this is a matter of judicial interpretation, is it not? Yes or no only, Mr.
Sure,
Speaker?
yes.
So, and the Congress has no power to interpret the Constitution or any law for that matter, correct?
No.
Okay, so that means that this is better left directly to the hands of the court, which has the power to interpret and determine whether or not the quo warranto is prohibited in this case, correct?
Sure.
So, okay, so have you read the case of Tomasio versus Paredes?
Enlighten me.
So, in that case, the Supreme Court ruled that the right to hold public office shall be determined by quo warranto. Okay? So, therefore, you have to agree with B that since the validity of her office is being questioned,
That's an open dictum.
due to her unproven integrity, a quo warranto proceeding should therefore prosper, correct?
The officer in that case is an
Yes or no only, Mr.
non-impeachable
Speaker?
officer.
Yes,
Is an
only,
elected
yes,
officer.
yes or no only, Mr. Speaker. So, next question. Have you read the quo warranto petition against CJ Sereno?
Yes.
So, have you read the ruling of the court in Villanueva versus the Judicial and Bar Council?
Please enlighten me.
So, are you aware that the Supreme Court ruled in that case that the JBC has authority to set the standards or criteria in choosing its nominees for every vacancy in the judiciary?
Yes.
So, would you agree with me that the JBC is accordingly empowered to require documentary and other evidence from all judicial aspirants which the JBC believes stand to prove their satisfaction of these qualifications?
Yes.
So, have you read Rule 4 of the JBC rules, where the JBC laid out the guidelines on how it will verify an applicant's integrity?
Sure.
So, just to clear things out, you agree with me that integrity is a requirement of the JBC for the Chief Justice post?
Yes, in fact, they relaxed
Yes or no?
the same.
Yes or no?
They
Again,
relaxed
as
the
I've
same.
said earlier, there was no substantial compliance.
They relaxed the same rule in favor of Chief Justice Sereno.
Let's now hear from the second affirmative speaker. Ado, you've got 4 minutes to tell us why it would be beneficial to consider the petition for quo warranto filed against Ms. Sereno as proper, considering her appointment was void ab initio.
Advancing the cause of a quo warranto petition against the Chief Justice is not an attack against the Supreme Court. Rather, it is a move towards the preservation of the judiciary's independence and integrity. Your Honors, good afternoon. Before I proceed with my speech, let me first rebut one of the key points of the first speaker of the negative. The case he had been citing, Your Honors, were actually cases related to disbarment and criminal case, which does not apply here in our motion, because we're talking here about the validity of the office that CJ Sereno had already, that CJ Sereno is actually in. Now, it is clear that her office is void ab initio because of her failure to submit kasalit. Therefore, we submit that quo warranto petition is actually correct. Now, Your Honors, to proceed, as second speaker for the affirmative bench, I am here to argue the beneficiality of the quo warranto petition against CJ Sereno. I hinge this conviction in 3 arguments, Your Honors. First, a quo warranto proceeding would enable the Supreme Court to police itself and avoid a highly politicized impeachment trial. We on the affirmative bench agree with Solicitor General Jose Calida that a petition for quo warranto is actually a better alternative than an impeachment trial. Recall the circus which surrounded the impeachment. Yes, Your Honor?
Are you not convinced that the filing of the quo warranto is just to sideline or gain time in the impeachment proceedings that is supposed to be filed with the Senate?
Thank you, Your Honors. I think, Your Honor, that is just a mere speculation, Your Honors, because we do not condone the act of CJ Sereno not actually having an integrity with her appointment in the office. Therefore, we submit that Quo Warranto is just proper, Your Honors, in this case. Let me proceed, Your Honors. A better alternative is a Quo Warranto that we submit. Recall the circus which surrounded the impeachment of Chief Justice Renato Corona. He was subjected to a harsh public trial which contributed to the deterioration of his health and the erosion of independence in the judiciary enjoys. In the case of Lagman versus Pimentel, it was stated that the court is called upon to practice its studied independence. It should show that it is an institution that can look beyond political pressure. The Supreme Court is better left to itself to discipline one of its own if need be and to examine whether or not CJ Sereno did in fact violate the Constitution by not submitting her SALN, away from any interference of public opinion and the grandstanding ever in Philippine politics. Second, Your Honors, a Quo Warranto petition bears as chief merit its being cost-effective, thus making unnecessary the conduct of an expensive and protracted impeachment trial in the Senate. Based on the previous impeachment of Chief Justice Corona, the Congress sitting as an impeachment court spent more or less 6 million pesos for the trial using taxpayers' money. However, the financial toll of the trial is not as expensive as the cost in terms of time and productivity in the exercise of the legislature's regular function. Hence, a Quo Warranto petition is better and more beneficial, Your Honors. Third and lastly, Your Honors, the Quo Warranto petition moving forward will send a strong message in precedence in the international arena that integrity and honesty in the judiciary in the Philippines is not a matter to be trifled with. The United Nations Basic Principles in the Independence of the Judiciary declares that persons selected for judicial office shall be individuals of integrity. These basic principles were unanimously adopted during the 7th United Nations Congress in the Prevention of Crime and Treatment of Offenders in 1985. These basic principles constitute a binding legal obligation to the Republic of the Philippines. In taking cognizance of the Quo Warranto, Your Honors, it actually weights the merits the Supreme Court would echo the ideals of the Bangalore Draft Code of Judicial Conduct that persons selected for judicial office shall be individuals of integrity. Although, ladies and gentlemen, if we truly want to preserve and uphold the independence and integrity of the judiciary, then this Quo Warranto petition must be accommodated. Thank you, Your Honors.
2 minutes for the cross-examination.
Good day, Mr. Speaker.
Hello.
I assume that you are well versed in the 1987 Constitution.
Yes.
I assume that you all know the contents of Article 8, Section 7.
Yes.
Did you see any indication therein which a reader that it requires sign-in for the position of Chief Justice?
No, it does not, but it requires
Okay, yes or no? Yes or no?
No.
Okay. Would you agree with me that integrity is a mandatory constitutional requirement?
Yes.
Okay. Would you also agree with me that it is the JBC that determines the qualifications of integrity?
Yes.
Okay. Are you aware of the JBC rules, in particular Rule 4, Section 1?
Yes.
Okay. Are you aware? Would you agree with me that pursuant to Section 1, Rule 4, JBC has the discretion to adopt means in ascertaining integrity?
Yes, of course.
Okay. Would you also agree with me that it is within their discretion to accept the certification given by CJ Sereno to prove her integrity in view of the standard requirement?
Yes.
Okay. So you are now siding with us that okay.
It's a public wrong. Therefore,
Okay,
this must be
Mr. Speaker,
accommodated.
please respect my time. Okay,
Okay.
have you read Villanueva versus JBC?
Yes.
Okay, the court stated therein that JBC has the authority to set standards or criteria in choosing a nominee, right?
Yes, yes.
Okay. Would you now agree with me that choosing to waive the salary requirement in 2012 is also within its authority?
No.
You're now consistent, Mr. Speaker. No further cross.
Nico, you've got 4 minutes now to rebut Ado and advance your argument on why it would not be beneficial to consider the petition filed against the Chief Justice Sereno as proper.
Your Honors, just a point of rebuttal before I proceed with my constructive. The negative, the affirmative bench misleads us by saying that Quo Warranto is more speedy, but Quo Warranto requires the submission of pleadings and at the same time, a grant of motion for reconsideration is at hand. Whereas in impeachment, it entails the mandate of the people that the operation of the Constitution must give place, considering that Section 3 of Article 11 provides that impeachable officers must be removed by impeachment through impeachment by Congress. Going now to my constructive, Your Honors. The negative side would like to stress that the proposition is non-beneficial based on the following grounds. Firstly, it undermines the supremacy of the Constitution, and secondly, it undermines judicial independence. As to my first argument, it is non-beneficial because Article 8, Section 7 provides the basic qualifications that a nominee must possess to qualify as a member of the Supreme Court. The list does not in any way require the submission of silence. The negative side does not deny that integrity is an absolute requirement, but it must be noted that compliance to the requirement of integrity is left to the determination of the Judicial and Bar Council. Section 5, Rule 4 of the JBC rules enumerated the grounds for disqualification, and it does not include the non-submission of salient. JBC is empowered to adopt other means to ascertain integrity, and when Chief Justice Sereno was shortlisted, the JBC, in their wisdom, was satisfied that she met all the qualifications provided in the Constitution and none of the disqualifications in the JBC rules. In the case of Plato versus PNP-CIDG, the court ruled that non-filing of salient per se does not constitute dishonesty or gross misconduct tantamount to lack of integrity unless done with intent to make false statements. In this case, Your Honors, the Chief Justice has no such intention. Her reason behind the non-submission is not for malicious concealment or to make false statements, but because such requirement was relaxed by none other than the JBC itself, not only to her, but to other candidates as well. Hence, Sereno's submission of 3 salients at the most is a mere error of judgment on her part for thinking that she already substantially complied with the JBC requirement. In Hardalesa versus Sereno, an error of judgment does not constitute a question of integrity. On to my last point. To grant it, it's non-beneficial because it will undermine judicial independence. To elucidate, a quo warranto, unlike impeachment, do not preclude the filing of another petition based on a different ground after the first one is denied. Your Honors, the justices of the Supreme Court cannot be burdened with such litigation because the very nature of their position is a matter of public interest as they serve as the final arbiters of all disputes. Angara versus Electoral Commission is enlightening. Thus, if granted, the petition will set a dangerous precedent of exposing the highest tribunal to undue vexation, affecting their official function, which in turn undermines judicial independence. In Fortune versus Labang, the court highlighted the importance of preserving judicial independence because for all intents and purposes, there is already a fusion between the executive and the legislative branches. Dear Honors, are we to twist the letters of the Constitution to give meaning to what is already clear, to provide what is not written in the first place? Democracy as an institution rests on the premise of the rule of law. In Sabio versus Gordon, the court pronounced that the Constitution is the highest law of the land, the basic and paramount law, to which all other laws must conform. Otherwise, the pillar which holds society together will be eroded as society slowly descends into anarchy. Its effects to the ordinary Juan de la Cruz is not beneficial because the organic law which protects them can be circumvented at the expense of procedural and substantive due process. This, Your Honors, to our mind benefits no one. I've already mentioned.
2 minutes for the cross-examination.
Hello, Mr. Speaker.
Hello.
Yes or no answers on it.
Okay.
Now, would you agree with me that integrity is closely related to, or if not, okay, approximately equated to an applicant's good reputation for honesty?
Yes.
Okay. Now, are you aware that in an announcement dated on June 5, 2012, the JBC required all applicants for Chief Justice to submit their salients for at least 10 years prior?
Yes.
Okay. Now, are you aware that CJ Sereno actually admitted that the salients she filed were actually incomplete?
Yes, but because that was relaxed.
Just yes or no? Just yes or no?
Okay.
Okay. And that statement was actually present in her comment against the co-warranto petition, right? Have you read the comment?
Yeah, I've read that.
Okay. Now, so basing on the admission alone, isn't that a manifestation of her unproven integrity? Because
No, because she
knows that-
submitted other certifications in line with the JBC rules, which
But her
JBC
science are
satisfied.
incomplete.
No,
Her science
because
are
the
incomplete.
because the
She
JBC
admitted that her
itself.
science were incomplete.
Because the JBC itself relaxed the rules.
Okay, let me show you a bigger picture. She was aware that some of her salients were missing, but she filed it anyway without disclosing her deficiency. Does she embody integrity and honesty, Mrs. Speaker?
Yes.
Are you sure?
Yeah. She
Okay.
embodied
And these
integrity in all
characteristics
aspects.
are required not only by our law, but also by international sphere, correct?
Oh yes. But
Aren't you?
salients are only required for government employees, not those acting
But
in
the fact
honorary
that you know that your
capacity, and
science were
also for those
incomplete and
part-time
yet you did
employees
not
in the
disclose it to
College
the
of Law.
JDC, that is tantamount to unproven integrity, Mr.
No, that's not tantamount. There's no hard improvement.
Now let's talk about the cost, Mr. Speaker. Do you know how much the previous impeachment trial of CJ Corona costs?
Yes.
Okay. Now did you know that the Senate and the House spent more or less 6 million pesos for the trial, and that's using the taxpayers' money?
But does beneficiality outruns the mandate of the Constitution? The answer is no.
And would you agree with me that with more time spent on impeachment proceeding means less time spent by the Congress in exercising their regular legislative function?
No, because it is their function
Of course.
pursuant to Section 3, Article 11 of the Constitution.
Let's now hear from the third affirmative speaker, Glamoury. You've got 4 minutes to tell us about the practicability of the proposition to consider the petition for quo warranto filed against Chief Justice Maria Lourdes Sereno before the Supreme Court as proper, considering that her appointment was void ab initio.
Ladies and gentlemen, there is no doubt that the validity of CJ Sereno's appointment is a justiciable question, which is very well within the ambit of the Supreme Court. Good evening, Your Honors. As the last speaker of the affirmative side, allow me to present first our rebuttals and argue on the practicability of tonight's motion. First of all, the Constitution, Article 11, Section 17, expressly provides that a public officer or employee shall, upon assumption of office and as often as thereafter, as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. Therefore, SAL-N is required. Second, on whether the Congress is divested of its authority to decide impeachment cases. Your Honors, this is precisely a question on the validity of CJ Sereno's appointment. A quo warranto is proper because she is unlawfully holding an office which she is not qualified for in the first place. Therefore, we are not divesting the Congress of its power to decide impeachment cases because impeachment would not even be proper since by virtue of that void appointment, she was never even an impeachable official to begin with. Next, that this would further destroy the reputation of the judiciary, it's actually the opposite, Your Honors, because a quo warranto proceeding would enable the Supreme Court to police itself and avoid a highly politicized impeachment trial. And to be shielded from unnecessary political pressure is exactly what we want out of this quo warranto proceeding. Now on to my constructive. There is no doubt that the validity of CJ Sereno's appointment is a justiciable question because we must remember that the Supreme Court has supervisory powers over the JBC. Article 8, Section 8 of the 1987 Constitution provides that the Judicial and Bar Council is hereby created under the supervision of the Supreme Court. Now, CJ Sereno's failure to meet the requirement on the submission of SAL-N for 10 years is a justiciable issue involving application of JBC rules and requirements for appointments in the judiciary and thus needing a definitive ruling from the High Court. The Supreme Court has in the past exercised its general supervision over the JBC, such as in the cases actually provided for by the negative side. In appointments of Honorable Valenzuela and Honorable Vallarta, in Hardeleza versus Sereno, and in Villanueva versus JBC. In these cases, Your Honors, the Court has shown us that the JBC's exercise of discretion is not infallible and that it can commit errors that violate the Constitution or even its own rules. And these errors or abuse of discretion should not be left unchecked, and therefore the Supreme Court can step in. Justice Brion in the Villanueva case actually emphasized that the JBC's independence as a constitutional body cannot be invoked as a means to avoid judicial review, more so when the assailed acts of the JBC involve grave abuse of discretion. In this case, Your Honors, ladies and gentlemen, it is very evident that the JBC blatantly committed grave abuse of discretion in shortlisting Sereno for the CJ Chief Justice post in 2012, despite her apparent failure to comply with their own requirements and rules. Therefore, the validity of her appointment is very much a justiciable issue and not merely a political one. And thus, this quo warranto can proceed as it is the duty and authority of the Supreme Court to ensure that the illegal... Yes, Your Honor.
Are you equating the responsibility of recommending the appointment of Chief Justice Sereno to the President, to the workings of the JBC?
Not necessarily, Your Honors, but we have to discuss the role of the JBC in this case because it is an inevitable and necessary consequence in addressing the issue of the validity of CJ Sereno's appointment, Your Honors. Now to close, therefore the validity of her appointment is very much a justiciable issue, and this quo warranto can proceed as it is the duty and authority of the Supreme Court to ensure that the illegal enlistment of Sereno by the JBC is nullified. And we have to